We are hearing from Sheriff Tommie Johnson of Oklahoma County tonight after county commissioners denied his request to hire legal counsel. The sheriff wanted his own attorney in the ongoing fight over whether his office is legally required to transport detainees to and from the county courthouse.
County commissioners argued Sheriff Johnson's in-house legal staff could represent him. But the sheriff tells our Spencer Humphrey he believes the denial is part of an effort to stop him from winning this fight.
When the county formed the jail trust, they wrote a document called an indenture laying out the trust's responsibilities. Commissioner Brian Mon, who helped write it, says they specifically left the responsibility to transport detainees with the sheriff, not the trust.
And we did that because it seems most appropriate that law enforcement be responsible for transporting.
But Sheriff Tommie Johnson says state law makes clear that was not legal.
State statute clearly says that once you have a jail trust, they have all the duties and responsibilities that the sheriff had when he or she was running the jail. You don't get to decide what to do and what not to do.
He argues when the previous sheriff signed on,
the sheriff was signing on as a vendor, like any other vendor, whether it's medical, food, you name it. You are a vendor and have the ability to exercise contractual obligations.
Earlier this year, Johnson says judges at the county courthouse became concerned over a lack of security. At the same time, he says members of the jail trust were trying to figure out how to reduce their nearly $6 million budget deficit. So he decided to pull out of what he believes was a voluntary transport contract and reassign those deputies to protecting the courthouse.
At that moment, I saw the ability to both sides can win here.
District Attorney Vicky Behenna disagreed with Johnson's interpretation of the law at a fiery jail trust meeting this month, arguing he is legally bound by what the indenture says, also pointing to a recent Attorney General's opinion agreeing with her interpretation. At the same time, though, also citing false examples of other sheriff's offices and jail trusts she claims operated the same way as Oklahoma counties. Then at that same meeting, Johnson and the jail trust agreed to extend his transport services another few weeks as long as the jail started sending some of their officers to train with his deputies. But Commissioner Mon says that wasn't legal, telling us he instructed the jail not to send their officers to train.
I did not think they had the jurisdictional authority to co-participate or certainly have the sole responsibility of transporting the inmates.
So when those jail officers never showed up, Johnson stopped transporting. A judge then ruling Johnson would need to continue transporting until he and the jail trust work out their disagreement in court.
And this is protecting the office of sheriff, not just for me, for the current sheriffs across the state and the future ones that will come, making sure that the authority they have is observed and is followed through.
This week, the sheriff's office tried to hire a law firm to represent them in that fight. It's the same law firm county commissioners approved the county assessor's office to use when it was involved in a lawsuit a few years ago. But when Johnson's office went before county commissioners to get approval Wednesday, commissioners denied it, arguing the sheriff's office should use its own in-house counsel instead.
Why would you not like me to be able to have adequate representation? You approve it for everybody else.
Johnson also points back to a tense exchange he had with DA Behenna at that meeting.
My office also,
yes,
as you know, also gets pulled in to represent the elected officials that are sued when bad things happen at the detention center.
And I'm glad you brought that up, because you have not once ever represented me in any situation.
What do you
As a
mean
matter of fact, you have went behind my back to all our colleagues and told them to sue me over this situation. I was made aware that she went to the jail trust chairman and told him to sue, and then I was also told that there was an email exchange between commissioner offices, and an email was sent with a list of individuals to use to pursue that lawsuit.
We obtained a copy of that email Behenna sent at least one county commissioner listing attorneys she recommended to hire. It did not indicate a specific issue, though, she thought they should hire them for. We asked Commissioner Mon if he received it.
No, we were working in conversations about trying to have peaceful resolution. As for me, I haven't been approached about suing him. It's just about what are the scenarios in the event that we have something fall apart.
But Johnson believes something more is going on.
There are what I believe on purpose roadblocks being placed in the way, but that will not deter me.
In a statement earlier this month, DA Vicky Behenna's office said the Attorney General's opinion about the transport issue, quote, confirms what this office, she says, has consistently maintained. Under Oklahoma law and the trust indenture, detainee transportation between the Oklahoma County Jail and the courthouse remains the statutory responsibility of the Oklahoma County Sheriff's Office.